dokumento para ma-turn over ang unit na kanyang binibili nga at binabayaran doon sa the columns.
Sudahan natin, Attorney Joey, ano kayang ibig sabihin ng accompanying note na yun, nung binasa at pinamarka ng depensa bilang crucial na ebidensya or bagay na hindi dapat matamper?
Kung tatandaan natin, itong unit sa columns na pinag-uusapan ngayon ay nakalista sa SALN ni Chief Justice Corona. Lamang, ito ay hindi nailista sa kanyang SALN hanggang noong year 2010. Okay? Ngayon, siyempre, ang gustong sagutin ng depensa or patunayan ng depensa dito ay merong basihan kung bakit 2010 lamang nila nilista itong property na to, gayong ang sinasabi na ayon sa SALN is na-acquire ito noong 2003. So ano ngayon ang basihan kung bakit matagal bago nalista sa SALN? At ang gustong patunayan ng defense team is that itong handwritten note na ito na may petsang June 2008 ay nagpapatunay na noong 2008 hindi pa yari ang condominium unit sa columns na sapat na mailipat o matanggap o maokupa ng mag-asawang Corona. So ito siguro yung dahilan kung bakit ingat na ingat silang patunayan itong sulat at ilagay sa list of evidence para sa defense.
Attorney Manix, ano yung naging implikasyon nito? Ngayon na binubuo na nga yung cross-examination, lalo na't na-cite nga yung sinasabi natin na note 10, ano yung pinaka-importanting bagay na pinopoint out yata ng depensa dito?
Doon sa sulat. Yun nga, parang gina-justify nila yung delay in including that particular property in the son of Chief Justice Corona. No? So, although, ayon nga sa sinabi ni Joey, Attorney Bernabe, meron pa ring taon na dapat na ilagay na siya, as early as 2009 siguro, dapat na ilagay na siya, assuming na i-transfer na yung title around that time. No? So, at least for 2009, meron pa rin pagkukulang dun sa disclosure.
At bago nga itong si Ms. Josef ay nag-continue itong cross-examination naman nitong witness bago sa kanya, itong representante ng SEC. At tinanong dun sa cross-examination by Justice Cuevas, tinanong niya itong witness mula sa SEC kung alam ba nito yung tungkol sa cheque na nagkakahalaga ng milyong-milyong piso para kay Cristina Corona na ibinayad umano ng City Government of Manila para sa pagbili ng property nito. Bakit po, Attorney Manix, bakit po ito tinanong ni Justice Cuevas at anong gusto niyang patunayan?
Well, una-una, kini-question niya yung kaalaman ni Director Katarungan doon sa, let's say, the whole scope of operations ng korporasyon, no, na obviously hindi naman talaga masasagot ni Director Katarungan yun. Kaya yung tanong ni Justice Cuevas is precisely to prove that point na yung ibang bagay hindi masasagot ni Director Katarungan.
The Honorable Court, once more. Ms. Joseph, you have given to me again another letter dated for June 2008 addressed to one Cristina Corona, signed purportedly by one Carmina A. Cruz. You have also handed to me what appears to me to be two copies of one letter dated 26 February 2008, addressed to one Cristina Corona, consisting of 2 pages, again appearing to me to have been signed by one Carmina A. Cruz on the second page. Actually, there are 2 copies also of that same letter I referred to, of dated for June 2008. Now, I note, Ms. Joseph, that in this letter of 4 June 2008, there is mention in the second paragraph. I will hand this letter to you. We shall already deem and consider the unit as having been delivered and accepted as of June 2008. Can you go over this and confirm if I read that particular entry in that letter correct? correctly?
Yes, sir. It says here, however, acceptance of the said unit should be on or before June 7, 2008. Should the unit still not be accepted by then, we shall already deem and consider the unit as having been delivered and accepted as of June 7, 2008. So,
Thank you. This other letter of 26 February 2008 also mentions, and if I may read, and please confirm if I'm reading it right. The unit has been deemed delivered and accepted as of February 28, 2008. I'm showing this letter again to you, which you have produced. And read the first paragraph thereof, insofar as that particular portion that I have read for the record.
yes, sir. As we have written in our notice last October 17, 2006, please attached copy regarding the final reinspection of your unit, we would like to inform you that the unit has been deemed delivered and accepted as of February 28, 2008. This is pursuant to Section 7 of the Contract to Sell, which reads, shall I read the rest, sir?
Yes. On the basis of that letter, there was a pre-inspection made. Am I right?
Yes, there's a mention of a final reinspection of your unit, sir.
Final re-inspection.
Yes, sir.
May we have this second, only one of the two letters, that last one, that from where you read that particular portion, be marked as our exhibit 48, consisting of 2 pages, Your Honors, please. Can you state for the record then, just to clarify this matter so I can leave this point, Ms. Joseph, when was the actual acceptance by Mrs. Corona of the unit in question?
We have no record, sir, of Mrs. Corona signing an acceptance form, sir.
What will be the significance, if any, of that statement of yours, that you have no record of Mrs. Corona accepting the unit?
Sir, based on our records, we have only a record that it has been deemed accepted based on the provisions of our contract to sell.
So you want us to understand, in this court to understand, that there was no actual acceptance, except that deemed acceptance that you were referring to?
Based on our records, sir, yes.
There is can you confirm, I have here a letter of 6 April 2011 addressed to the Board of Directors. The columns, Ayala Avenue Condominium Corporation. It's handwritten. I just have a machine copy. The original must be with you. If you have it, please confirm. May I show this to you and ask you whether or not you have seen this letter before?
The letter is being shown to the witness.
No, sir, I have not seen this before.
Would you know if after the deemed acceptance of the unit by Mrs. Corona, Mrs. Corona or a representative of hers for that matter paid the association dues?
Sir, the dues are paid to the condominium corporation, which is not part of a developer responsibility already, so we have no records of any of the payments of Mrs. Corona to the condominium corporation.
Ordinarily, Ms. Joseph, is it not that a developer insofar as the unsold units are concerned, actually subsidize the dues for these unpaid or unsold units?
For unsold units, sir, since the owner will be, if it's still in the name of Community Innovations, then Community Innovations pays its condominium corporation dues like any other member of the condominium corporation.
Would that mean, but correct me if I'm wrong, would that mean that the Community Innovations Inc. Will be a member of the Columns Ayala Avenue Condominium Corporation, the association?
Sir, if there had been units at that time, yes, sir.
Okay. And who would be in the best position?
Just a minute. If there were units at the time, what do you mean by that? Units unsold and unaccepted.
Units that are, once the unit has been transferred, sir, to the buyer, then the buyer is now the owner of the
But
unit.
those units not yet sold and not yet accepted actually by the buyer are still subject to the responsibility of the condominium developer with the association.
Sir, our reckoning point is the transfer of the ownership of the condominium. So once the condominium is already transferred in the name of the buyer, then the buyer becomes an automatic member of the condominium corporation.
Councilor.
Thank you, Your Honor. Ms. Joseph, was there delivery based on your the record you brought here to this court? There any record of the delivery to the unit? I mean, the buyer of the unit, in this case, Mrs. Corona, of a copy of the tax declaration of the unit involved?
We have a copy of the tax declaration in the name of Mrs. Corona, sir.
When was this copy of the tax declaration delivered based on your records? Witness for the record is examining two letters.
Sir, there's a date here of 6/29, 2007, sir.
2007,
sir.
Okay. Thank you.
May we request, Your Honor, that the said tax declaration produced by the witness be marked, Your Honor, as prosecution's exhibit PPP-5, Your Honor.
Mark it accordingly.
Is there a covering letter, Ms. Joseph? Is there a covering letter of that tax declaration?
We have a copy of the tax declaration, sir.
But is there a covering letter delivering that?
During the delivery, sir.
No. A covering letter of that tax declaration addressed to Mrs. Corona. 2007 daw.
Nasa kanya ho eh.
Kindly answer the question whether there is or there is none.
We have a covering letter, sir. It's dated June 11, 2008, where we said that where we had enclosed a copy of the tax declaration, which is in the name of the buyer.
We manifest, Your Honor, that that letter referred to by the witness has been previously marked